All right. I think we're going to get started. Welcome. I'm Lisa Held, Civil Eats Senior Staff Reporter and Contributing Editor. Welcome to our conversation inside a historic Supreme Court case on pesticide risks. Whether you're joining us live or watching this recording later, we really appreciate you taking the time to be here. Especially this week, there's a lot going on if you're someone who cares about these issues. For those of you who are new here, Civil Eats is a nonprofit news organization with a mission to broaden and deepen the conversation around the American food system. A couple of housekeeping items before we jump in. We are recording this salon to share afterwards. We're going to keep all the participants muted, but we really encourage you to engage with each other in the chat throughout the call. And you can add your questions there for me and for Nathan. And at the end, we'll be taking note of your questions throughout, and then we'll get to as many as we can in the Q&A later. So I'm so happy to be here today with Nathan Donnelly. He is the Environmental Science Director at the Center for Biological Diversity. Nate has a doctorate in cell and developmental biology and has studied the links between exposure to environmental toxicants and cancer. I have to say, this is sort of the Lisa Held version of Nate's bio. He is one of my most trusted sources on these issues. He always knows what's going on in the EPA pesticide office. He's ahead on issues like the EPA approving pesticides that qualify as forever chemicals and so many other things. So, Nate, thank you so much for being here.
Yeah, thanks for that kind intro, Lisa. Happy to be here and excited about this conversation.
Great. So we have a lot to talk about in the next half an hour. I do want to just mention that I spent the morning watching the House introduce amendments and then vote on a farm bill that they passed, which was something that we thought was going to happen and then it wasn't going to happen and then it ended up happening. And it's really relevant to our conversation today because there was a provision in the House Farm Bill that would have given immunity to pesticide companies like Bayer. And at the last minute, one of the last amendments stripped that out of the Farm Bill before it passed. So I feel like it's pretty significant. And I do want to ask, we're going to get to that, but I think we need to do some background first. But I want to make sure, kind of note that that's like where we're coming from, today. I was working on that all morning. So, but yeah, we're here to talk about the Supreme Court case on pesticide companies' liability. Nate, where I want to start is for people who haven't been following the sort of long path that led here, can you give us just a brief rundown of how this case came to be? Why did individuals who use Roundup start suing Monsanto, now owned by Bayer? What are the claims based on?
Right. So yeah, I mean, broad overview, over the past many decades, people have been using Roundup on just about every bit of land in the US to kill unwanted plants. It's incredibly popular and it's incredibly effective. And this rise in use was really facilitated by the belief that glyphosate, which is the main ingredient in the Roundup product, was completely safe. So for decades, people have been using this pesticide very liberally, often without much protective clothing at all, because it was just kind of considered as safe as the water coming out of your garden hose. It's not uncommon to be out in the burbs and see someone with, applying this stuff on the ground in flip-flops and shorts. So, exposure has been really sky high. And no one really questioned this very seriously until 2015 when the IARC, which is the World Health Organization's cancer research arm, found that glyphosate was a probable human carcinogen. And very quickly you started seeing, thousands of people sue the company who had very high exposure to this pesticide in their lifetimes and had developed non-Hodgkin's lymphoma, which is the main cancer associated with glyphosate exposure. And these lawsuits were extremely successful. So cancer victims were getting compensated on the order of hundreds of millions of dollars. And these cases really exposed how Monsanto which was acquired by Bayer, misled the public and knew about the harms associated with their product. And the reason this case, out of the thousands, made it to the Supreme Court is because there was a circuit split, which meant that the appeals courts that heard this case, two found in favor of Darnell, which is the cancer victim here, and one found in favor of Bayer. So circuit splits can be one factor in the Supreme Court deciding to hear a case. So in terms of the claims at issue here, in the state tort lawsuit, the Darnell case dealt with what's called a failure to warn claim, which essentially means that the company should have warned the customer about the risk from their product, but failed to do so. And then in the subsequent Supreme Court case that we're talking about now, they're wrangling with whether federal pesticide law preempts or nullifies that failure to warn claim at issue in the Darnell case, and would basically shut down, these lawsuits, these thousands of lawsuits waiting in the wings.
Yeah, and I wanted to ask you about that, that idea that it would kind of shut down, like if the Supreme Court rules in favor of Bayer, that the expectation is that a lot of these lawsuits will be over. Some sources I've talked to have said that that's true, but that there are also other kinds of claims that are possible, and so it won't necessarily end all of the litigation, but a lot of it. What do you see as the actual outcomes, like the sort of like tangible outcomes, depending on which way this goes?
Sure. So, if, you know, I'll just say the court case here and all of the legislative and executive actions that have been happening for the past few years around this have all been geared towards one thing, which is federal preemption. You may have also heard it called failure to warn or immunity or a liability shield, but it all means the same thing, which is if Bayer wins, that means the EPA would have the last word on what warnings are put on pesticide labels. Um, and so if EPA declines to require a warning on a pesticide label, then you, as someone who is harmed by pesticides, would be unable to bring a failure to warn claim in state court. Now, there are other ways to sue for damages, as you said, but they are typically much more difficult to meet the legal threshold required, particularly for chemical harm, which is just notoriously difficult to show. So not being able to bring a failure to warn claim specifically really basically shuts you out of holding these companies to account and attain damages. So
Yeah.
federal preemption would basically work as a liability shield that way. It would be a major roadblock here. So if Bayer wins, people who have had their lives turned upside down will lose their ability to seek some semblance of accountability from these companies that willingly sell poisonous products to the public.
Right. Well, and preemption, that's sort of the core that you just said. And but it's even it has even a broader context, right? Like there's all these other state laws that where preemption comes into play. For instance, I know this isn't your focus, but right now a lot of states are passing laws around like food dyes, for instance. But also with pesticides, I know a lot of states have restricted the use of pesticides, for instance, like near schools or, passed kind of more restrictive laws versus federal law. Does this preemption conversation we're having about the Supreme Court, like, does it have a broader implication for all of those kinds of preemption?
That's a really good question. As the justices elected to hear the case, the conventional wisdom is that the ruling is probably going to be pretty narrow,
Right.
dealing with just language added to the pesticide label. So presumably that would not preempt states from, say, putting a no spray buffer between schools and where pesticides are applied. It would not impact states' ability to ban a pesticide that the feds still allow to use. So there's some of those sort of broader things that states can do. This case, would just really deal with things being put on the label that are not necessarily required by EPA, but states may do. I think it's an open question about whether Prop 65 warnings would be encompassed in this.
Mm.
Depending on how broad or narrow the justices decide this case, I think whether Prop 65 warnings will be allowed on pesticide products is probably going to have to be litigated further and, may end up at the Supreme Court again. So Prop 65 is a big question in my mind, but some of these broader, states being able to ban pesticides should not go away if Bayer wins here.
Can you just briefly explain what Prop 65 is for some people who are not familiar with California might not know about it?
Sure. Prop 65 is a law passed in California in the 80s that allows 𝘰𝘯𝘶, which is part of California's EPA, to place warnings on products that have ingredients that the state of California recognizes to be either a carcinogen or a reproductive or developmental toxicant. So a lot of times these warnings are just in California. Sometimes they're across the country because companies don't want to have two different labels. And so you'll see, Prop 65 warning known to the state of California to cause cancer. These warnings are incredibly important because they really incentivize companies to get rid of dangerous products in their products. So dangerous ingredients in their products, so that, we all are, you know, exposed to safer things in the environment. So it's been an incredibly important law, but it's been, in the ire of industry for decades now, and they really dislike it.
Yeah, yeah. Thanks for that. Um, so just briefly on the farm bill that I mentioned at the top. So the version of the farm bill that just passed the House is unlikely to go anywhere as is in the Senate. There's a lot of complications that are unrelated to this conversation that I won't get into that have more to do with SNAP and other issues. But do you think it's significant that the kind of push at the end to get this pesticide immunity clause stripped out of the bill was successful?
Yeah, I do. I think this is a huge win. Uh, it was not just the immunity shield. There were multiple really bad pesticide provisions that were stripped out. Almost every bad pesticide provision was taken out of the House Farm Bill that just passed. This bill is still a monstrosity, and I hope it dies a horrible death in the Senate. But chemical companies just got thumped by basically a ragtag group of lawmakers that came together across the aisle and lobbied hard to get these provisions taken out. Republicans and Democrats, and this would have just been railroaded through if not for the MAHA movement. And I want to give credit where credit is due. This was really an amazing win and would not have been possible without their pressure. Now the fight's not over. Who knows what's going to happen in the Senate, and then reconciliation between the two. The fight goes on, of course, but it's a really notable incremental victory here, I think.
Yeah. Yeah, I'm gonna skip around a little because that kind of relates to another thing I wanted to talk to you about, which is, the rally outside the Supreme Court that we covered this week was organized mostly by people within the MAHA movement, but also involved a lot of other organizations, including the Center for Biological Diversity. And it's called the People versus Poison Rally. I know like your organization has been critical of the Trump administration's actions over the past year, especially on environmental policy. Talk to me about why the center decided to kind of band together with this Maha movement coalition when it came to this rally.
That's a good question. And I think what drew us to this rally was that it was nonpartisan. You had Maha moms speaking alongside Republican and Democrat lawmakers. You had environmentalists, organic farmers, you had widows, cancer survivors. Everyone was speaking with one voice. And yes, there's some disagreement on some things, absolutely. And from our perspective, if you only work with people who you agree with on 100% of things, then you're not going to have any allies. You're not going to get much done. And the shared area of agreement with MAHA and liberal environmental and public health groups has extremely broad public support. Something like 80% of Americans think there are too many chemicals in our food and they want government to do something about it. So when you have 80% of the people agreeing on one thing, um, it transcends a single movement, and it's simply the will of the American people at that point. So in order to realize the potential, of our collective power, we need to work with people who we disagree with on some things and who vote differently than we do. So we welcome the opportunity to work with this movement on issues we agree on, like getting poisons out of our food, and we can just agree to disagree on the rest. There's nothing wrong with that. Whatever path has the greatest chance um, of changing our food system for the better is going to be the path that we're going to take. And I think more and more groups and advocates are starting to realize that, we're stronger together.
Sure, sure. Okay, so let's talk about we might come back to that, but I want to make sure that we really focus on what happened in court this week. That's why we're here. I was in the courtroom and um, I thought, it was pretty hard to tell which way the court is going to lean in the case. The justices seemed really skeptical of the Bayer attorney Paul Clement's arguments. They definitely asked him more challenging questions compared to the attorney for John Darnell, and one legal expert after said that when the justices kind of challenge one attorney more than the other, it generally means that they're more skeptical of that side of the argument. So that was one kind of just thing to take note of. But they also seemed really concerned about the uniformity of pesticide labels, which would be something that I would imagine would lean in favor of Bayer. I thought it was interesting that the questioning really it didn't break down along partisan lines, like the justices that lean right or left. It was Justice Ketanji Brown Jackson asked something, and then John Roberts kind of had the Chief Justice had like something that was building on her question, and so it was interesting to see that kind of to what you just said about the movement sort of on these issues not being partisan. I think in the court it actually was reflected that way as well. And yeah, and I mean, they were mostly very technical. When you're in the court, it's like the arguments are so technical, and it's a little hard to kind of square the language they use with how we talk about this out here in the world. But the main thing I want to ask you about is, well, there's two things. One is kind of this idea of a timeline. They kept coming back to the fact that federal law says that if a pesticide lacks adequate warnings, it's misbranded. And they kept coming back to, well, there's this 15-year gap between when pesticides are registered and when they get reviewed again. And what if during that time, the science changes? And then maybe state laws and courts are essentially helping to enforce the law because they can move faster. And so there was at least, I want to say like three or four times that they came back to this idea of like, well, what about that timeline? So I'm wondering if you can talk a little bit about why that might be important here in terms of how the science on glyphosate and Roundup has changed over time and how responsive EPA has been to that science.
Yes, that is a really good question. And you're right. Science is constantly evolving, and our the knowledge that underpins these pesticide decisions is constantly changing. So in a lot of ways, the pesticide label becomes misbranded the second after it's stamped. I mean, things are happening that quickly in a lot of respects. So in a lot of ways, um, you know, this idea that EPA updates its scientific assessment every 15 years is a fairy tale. They never meet that deadline. In fact, the farm bill that just passed the House has a provision in it that was kept, that gave them an extra 5 years to complete their assessment. And they already
Wow.
got a
I
previous,
didn't even know that. That's crazy.
yeah. And they've already gotten a previous extension on this years ago in the Pesticide Registration Improvement Act called PREA. So the last time glyphosate underwent a full review was over 30 years ago. I mean, 30 years ago, we didn't even know that PFAS were harmful. Uh, Endocrine disruptors were just first being described. So suffice it to say that a lot can happen between assessments. So states absolutely need to be able to step in when federal regulators are moving, at a snail's pace here. And I will say that all the interpretations of these various laws and the past court cases that they were citing, they all rely on EPA being an effective regulator of pesticides. This is just kind of inherently assumed in all of this. But no one's asked the question, what if the federal regulator isn't up to the task that they're given? And we actually wanted to know whether EPA was requiring cancer warnings on pesticide labels, even when the agency acknowledged a cancer risk. Right? EPA hasn't acknowledged that glyphosate poses a cancer risk, but for many other pesticides, they have acknowledged that. So we had AI, look at about 100,000 different pesticide labels that contained pesticides, and about 5,000 of those contained a pesticide that the EPA recognized as a probable human carcinogen. And we found that only 1% of those labels carried a cancer warning. So EPA has a 99% failure rate when it comes to warning the public of a cancer risk that they themselves acknowledge. Yet they were up at the Supreme Court asking for more responsibility. So it's just absolutely crazy, and it goes to show that the EPA that was being described to the Supreme Court justices in the court is not the EPA that exists.
Yeah, I mean that number I think will be pretty shocking to people. Those statistics that you just mentioned. Is it? I mean, it almost seemed. I read that report when you put it out, and it almost seemed like that's sort of like FIFRA, the federal law that regulates pesticides, isn't really set up to even include the idea of these cancer warnings in a way. Is that wrong? I don't.
No, that's absolutely right. I mean, EPA has to warn the public of acute harms. So, like, if the pesticide will
Right.
make you itch and give you a rash, that carries a warning. And generally, that's in the form of caution, warning, or danger, which are the like kind of three warning words that are given on pesticides. So, if a pesticide gets in your eye and immediately causes pain, that's going to be warned about. But there's really no regulations or guidance at all about warning about chronic health harms like cancer or Parkinson's disease or reproductive toxicity. So oftentimes the public is just completely in the dark on what happens if you use this product every year for 20 straight years. And that exposure kind of compounds on itself. What does that mean for your health? What does that mean for your overall quality of life moving forward?
Right. Yeah. And you mentioned kind of this idea that there are kind of flaws inherent in your mind in EPA's process in registering pesticides and making sure they're safe from the beginning. And one thing that I heard a lot from some of my sources is that one of the reasons that in these state courts, juries have really sided with litigants on these cases is that kind of that's sort of part of the reason because they hear all of this evidence that has to do with essentially science that the EPA hasn't considered or isn't part of the process. So, for instance, the jury in Missouri heard how Monsanto had evidence early on that rats exposed to Roundup developed tumors. There's long evidence documented that the company was ghostwriting scientific papers used to defend the chemical safety, but none of that was like is considered by EPA. Is that right? Like how do you think about like what is missing from the information that EPA considers when it registers a pesticide like Roundup?
Absolutely. I mean, what came out of the Monsanto cases what has really informed us about a lot of this is the documents released in the discovery process, which is internal Monsanto emails, all this stuff, going back to the 70s, based on, what Monsanto knew, how they had been hiding the harms from their products. 𝘋𝘰𝘯𝘴𝘢𝘯𝘵 has been, really amazing in highlighting a lot of the stuff released in these papers, as you put in the chat there. And it's just absolutely blown wide open that there is a disconnect between what this company knew and what federal regulators acknowledge to be the harms here. And I'll say that, one of the reasons why this preemption issue is so important is that it really gets at the heart of the problem here is that EPA is not really doing their job. There's multiple reasons why preemption matters. The most important, obviously, is that people deserve their day in court. But another is that, we're basically regulating pesticides via tort law in the US right now. And what I mean by that is that our pesticide regulatory system is so co-opted by the pesticide industry, that it fails at the basic function of protecting the public. So instead of preventing harm on the front end, which is what an effective regulatory office is supposed to do, people have been having to sue for damages from the companies on the back end, after the damage has already been done. And people have been winning these cases, and this isn't just with glyphosate. It's happening now with paraquat. It happened back in like 2010, 2012 with atrazine, chlorpyrifos, recently with dicamba and harm to crop fields, just to name a few. So tort law, suing for damages is only relevant if our regulatory system has failed. It's meant as a backstop, but it's morphed kind of into this first line of defense. And I'll say that the threat of litigation here is one of the only things keeping these companies somewhat honest. And just an example of that is Syngenta, which is a big pesticide company, just announced that they'll no longer make and sell paraquat. Now, paraquat's a pesticide that's banned in over 70 countries around the world. And crazy enough, we still use it here today. And yet we have the company voluntarily stopping selling the product in the US because they don't want to have to pay out money to victims anymore. I mean, think of that. Our regulators still allow a pesticide ban in 70 countries, and it was the pesticide company that had to say, this is too hot for us. So, if the fear of liability goes away, we truly have nothing here. And that's the core of the problem. We expect and we deserve so much more from our pesticide regulator.
Yeah. And that's kind of what Bayer has been saying as well throughout this case, is that they've sort of been floating that they will just pull Roundup from the market if they don't win, or if they don't, figure out a way to end the litigation, in the same way that you're just describing that, I guess, Syngenta has done. It seems, from what I've heard, that seems less likely to happen. But what do you think about that?
Absolutely. I mean, the thought that they would completely abandon their flagship product is just absurd, because keep in mind, all they have to do is put a cancer warning on the product, and this all goes away. Like, they're being so incredibly ridiculous about, not putting a cancer warning on there. They can do that themselves. EPA would stamp that if that's what Bayer wanted. And they could keep selling their product. That's all anyone is asking for here is a warning. And on Bayer's side, if you look at the friend of the court briefs, it's basically like the Chamber of Commerce and a bunch of farming groups, and their argument is all the same, that loss of glyphosate is going to cause, mass starvation, and their argument is very fear-based. It's meant to elicit this kind of quick knee-jerk reaction in their favor based on the fear of what may happen in Bayer's kind of revisionist world where, somehow a single chemical is needed to feed 8 billion people worldwide. And we saw these same arguments when DDT was banned. Also, when carbofuran was banned in 2009, which actually that case made it to the Supreme Court as well, and they opted not to hear the case, which left in place the lower court ruling which allowed EPA to ban carbofuran. But if you read the briefings in that case, industry was saying that, entire sectors of farming, entire crops would fold if carbofuran was banned. And of course, it never happened. It's just scare tactics. And they do this because unfortunately it's remarkably effective and it's meant to elicit a response from the justices. And that's why they're doing it. And we'll see if it ends up swaying things, but it's just absolutely infuriating that they make these kinds of arguments that are just hollow threats of not selling glyphosate anymore.
What I want to challenge you on one piece of that, and then we're going to go to we have some questions from the audience. But the idea that if they decided, okay, we'll just put a cancer warning on it, that the EPA would just let them do that. What is that right? Because I mean, the EPA still maintains, based on their evidence, that Roundup is not a carcinogen. It doesn't cause cancer. So how could they approve a label request from Bayer if it doesn't line up with with what they say the science is?
I mean, ultimately, FIFRA, which is the main federal piece of pesticide legislation, it's not an environmental law. It's a pesticide registration law. EPA is basically, the pesticide companies are their clients. That's how they're viewed, and that's how EPA treats them. Um, so, what EPA does is they don't necessarily approve labels, they accept labels. So if you look at a pesticide label, it says EPA has accepted this label. So what happens is generally the registrants, the pesticide companies, write the label, and EPA looks it over and says, "Yeah, fine with us." It doesn't conflict with federal law, basically. And so if the companies want to put a cancer warning on their product, they're allowed to do that. In fact, there are cancer warnings right now on products that have an ingredient that is just suggestive evidence of carcinogenicity. So, I think EPA would not be requiring this warning, but companies have put them on because they want to be protected from litigation. So, if a company comes to EPA and says, "We want a cancer warning here," EPA is not going to say no. They're going to do whatever the company wants. And then, they can call it a win on their part that, hey, look, we put a cancer warning on here. So I really think if Bayer wanted to put a cancer warning on there, EPA would have no problem with that. And then the company would be protected from these types of lawsuits and this problem would go away. But we're in this whole mess right now, and all of these terrible riders and farm bills and Supreme Court cases and executive orders, just because this company doesn't want to put a darn warning on their label.
Got it. I guess, yeah, it does. And I should have, it kind of lines up with the fact that, I mean, the companies are responsible for providing all the studies and everything, right? So it makes sense that the process kind of works that way. Let me ask, let's switch over. We have some questions coming in from the audience. This one, I'm not sure if you'll know about this, Nate. So the question is, what is the status of EPA's gathering of adverse impact complaints and reports? There was a database that was utilized in the pesticide registration process. I'm not sure about this.
Okay, there's a thing called the pesticide incidents database.
Right.
That has been under the Biden administration, we were able to get that publicly available. So I think if you just Google like pesticide incidents EPA, you should find it pretty quickly. But I don't know how often that is updated. Back in the Biden days, it was updated, I think, weekly or monthly. But it was, something we usually had to put in a public records request for to see how many incidents are associated with individual ingredients or products. But now that information is publicly available, which is really great. Not a lot of countries have this in place, so it's something that we have that I think is an important resource from a right to know standpoint. And as far as I know, that's still being updated. Although I have to admit, I haven't looked on that database for probably at least a year, so I could be wrong about that. But hopefully, that's still being updated and up and going, and it's publicly available now, which is great.
Great. I would just add though too that I mean I think it's great to have that a public resource where you can see the report, the complaints that have been reported or incidents. But a lot of the kinds of I guess quote, unquote, complaints we're talking about today, like people who have sued, those kinds of things probably wouldn't be reflected in a database like that because they're not a single incident. It's sort of something that develops over time, where you develop an illness after years of using something, right? So that incident report database is more about like you were outside and your neighbor was spraying and you actually got sort of like doused with a chemical, right? It's more of that kind of like outlier incident.
Yeah, there's very few incidents of chronic harm reported because
Yeah.
it's after the fact. It's very difficult to tie the harm to the product, and EPA generally says we can't find a connection here. So I would say 95% of the reports are acute harm, like I accidentally spilled this on my hand and got a really nasty chemical burn, and I had to go to the emergency room, stuff like that. And then there's also, these aren't just human incidents as well. These are incidents like if you go out and spray glyphosate on a really windy day and it drifts onto your neighbor's farm and kills their crop, that's an incident too. You also have wildlife incidents as well, so harms to animals like fish kills, or harms to like an endangered species or something like that. So this database collects all of that, and again, you're only getting what people report, which is just a small percentage of the actual harm that's happening. So it's not an exhaustive list of the harm associated with that product. It's just what people have observed. So keep that in mind as well.
Yeah, absolutely. I'm gonna go to this question from a farmer who says that they use Roundup and that it's effective and they operate on tight margins. What does this whole case that we're talking about mean for farmers on the ground in your mind? Specifically, how do we balance regulatory pressure, liability concerns, and the high cost of developing new chemistries so that farmers aren't left with fewer tools?
Sure. I mean, it's a valid question. It is. And I will say that nothing about this court case has to do with banning glyphosate. A loss for Bayer here means that things just go on status quo. People can keep bringing these claims. If Bayer wants to insulate themselves from this, they can put a warning on the label. If they want to go through with their empty threat of pulling glyphosate from the market, they can do that. But I will say that if Bayer leaves the glyphosate market, you will still have dozens of generic producers who will still gladly sell it and take over that market. So glyphosate's not going anywhere. What we want here is a warning. And I know a lot of farmers would be fine with that, right? A lot of farmers would look at a warning of cancer and say, you know what? I still want to use this. This is a risk I'm willing to take. Some wouldn't. But from a right to know standpoint, this is something that everyone should have a right to know about. And you can make your own decisions based on the risk calculus that you have. Um, and the fact of the matter is pesticides are harmful and they are causing harm to people. They're designed to harm life. And so since these are necessarily, dangerous products, they need to be used with care. And really what we need to do is get the worst of the worst ingredients out of here so we can focus on safer alternatives. And I hope we're able to do that and get to a place in this country where we can start getting rid of the pesticides that other countries have banned, and move forward in a much safer manner.
So we're running out of time, but I want to get to this one question because I think it's actually a perfect place to end. And it was similar to something I was going to ask you and I didn't get to. If Bayer loses in court, how could that impact the regulatory system, or is it just sort of we go back to fear of liability forever?
Well, I mean, you know, in the short term, I think, since this fight is being fought on so many different fronts, if Bayer loses, uh, we simply get to fight another day. It's not much of a prize, I know, but there's so many fights going on right now. The Farm Bill, Appropriations Bill, terrible riders, executive orders. If we lose just one, then we lose everything. So this is really kind of like David versus Goliath, but David has to win 10 out of 10 times. If we win 9 out of 10 times, we still lose. Because if just one court decision, if just one bill, if just one rider gets through, we lose everything. So you can kind of get a sense of the stakes here. And as far as how this, will impact the regulatory sphere, if they lose, I think the pressure uh, gets to be high, and EPA really needs to step in and decide, whether they're going to stick with their faulty cancer analysis that the Ninth Circuit Court of Appeals tossed out, or whether they're going to step up and say, hey, you know what? We need a cancer warning on this label and other pesticides that we recognize to be probable human carcinogens. That's just a bare minimum that they really need to meet. And I think, depending on the outcome of the Supreme Court case, there's going to be a lot of pressure on EPA to change either way. It just has to, and we've really reached kind of a fever pitch in this country where people are paying attention to chemicals issues more so now than ever, and that's not going away.
Yeah, it does. I mean, I've been covering this stuff for a long time, and it seems like these conversations are breaking into the mainstream in a way that they haven't in a long time, right?
Absolutely. I mean,
Yeah.
I've never seen this level of anger and mobilization and in a lot of ways excitement before on the actual potential for change happening.
Great. So we're gonna be wrapping up, and just before we go, I just want to say thank you so much, Nathan. We appreciate your time. And yeah, and during such a busy week, just being here with us and sharing your insights. And if you want to share in the chat before we leave something that you're taking away from today's conversation, please do, everyone who's on the call. And thank you to everyone who came and spent time with us today. Salons like this one are free because we believe these conversations are important and should be accessible to everyone. If you value this work, we hope you'll keep reading and consider supporting Civil Eats today or in the future. Thank you all so much. And yeah, we'll hopefully see you at another salon soon.